Okay. So what I was telling is that just if you have any clarification, you can stop me then and there, and we can move forward. We will discuss and move forward. Now, coming to pre-pack insolvency, the concept of pre-pack insolvency, you must have been, maybe few must be handling also, or few yet to handle. But we need to understand the basic why this particular pre-pack insolvency has come. In fact, before proceeding, I thought I can take your view so that it would be better for me to see that how I can take it forward next 2.5 hours time, whatever we are going to spend on this session to understand the pre-pack. So I think most of you must be practicing IP, maybe handling the cases also. How many of you are handling pre-pack? Anyone in the 30 participants? Anyone? Anyone is handling pre-pack? No. None of you? You feel pre-pack is not coming at all or not lucrative?
It is basically for MSME.
Okay.
And it is a very good because the management lies with the CD.
Okay.
So it is good. I am going to give one consent. Yesterday, I was in talk with some MSME, and I am going to give consent in this week.
Okay.
Hmm.
So looks like the participants who is here, none of you, I presume none of you handle the pre-pack. Okay. So that's good. Now we'll have, we'll try to handle the pre-pack with better clarity. So after this session, we'll try to understand the nuances and what are the important aspects of the pre-pack insolvency. Before taking you through the pre-pack insolvency, how it has come, and of course I got a PPT, a PowerPoint slide presentation of more than 100, about 130 pages I have. But before that, I want to give certain prelude. Why this pre-pack? So that it will be easy for you to connect with the why this particular concept has emerged. We have already have a CRP. You must be handling also. Many of you must be handling and must have experience in handling CRP. When there is already a process called CRP, then why there should be a pre-pack insolvency? We will try to understand all the sides of the pre-pack insolvency. And just like CARP, probably the days will come where pre-pack insolvency also gain more importance, and more cases are coming in pre-pack insolvency also. So now the pre-pack insolvency. Why this is called a pre-pack? Any idea why it is called pre-pack? Insolvency we all know. Why it is pre-pack? Because I don't want to simply take you to my presentation. Then after that, I have to run the presentation and restrict myself within the slide. Okay, what I'll be showing to you. So I thought better to, before going into my slides, I thought I can discuss a little wide the entire concept of the whole thing. Then I can take you to my slide so that I need not to, I can restrict to my slide after discussing the overall aspects of the pre-pack. So I thought before taking you to my presentation, I want to understand basically what is what and why we are today discussing pre-pack and why this concept of pre-pack itself is introduced. What went into the mind of the government that they have to bring a pre-pack. Any idea why it is called pre-pack?
So everything is decided, pre-decided in this pre-pack. So a resolution plan is there, base resolution plan is there. Creditors are more or like they agree. Corporate debtor, they are also agreed. Good. So and the management remains with the corporate debtor. and there is a timeline also. So everything is pre-decided. That's why it is called pre-pack,
Good.
in my view.
No. It's a correct view only, and there cannot be any other view other than this. See, idea is here, the pre-pack is that, as you said, rightly said, the package is already, frozen. Before going into approaching the adjudicating authority, the package is already frozen. And at least the financial creditors, okay, the future COC member, once it is once the application gets admitted, who going to be a COC member, so they aware much before the application is moved and what is going to be the package that they are going to get, and what is the package that they are in principle agree before going to the NCLT. That's why it is pre-packed. In fact, I have to say that one good example for this, probably you can easily connect thereafter to that. The participants, any one of you, have you handled any restructuring thing, loan restructuring? We offer settlement, right? OT.
Right. OTS.
Anyone has involved in OTS kind of settlement? Anyone handle?
Myself.
Yeah. Can you share your experience on OTS so that I can connect that to a pre-pack?
Actually, the company in which I was working, they have taken a huge amount of loan, and they were unable to pay its debts, as well as they were unable to serve its interest.
Okay.
So the bank has, before going to NPA, they have asked to settle this matter,
Okay.
and the OTS has been resolved.
Okay. So what is the process? What is the process followed? That only I wanted to link with the pre-pack, connect with the pre-pack. The process that is followed.
Sir, I am unable to tell the whole process because other persons are also
I'll
involved.
put it this way.
Hmm.
Basically, OTS is that one-time settlement,
Right.
where the financial creditors, the bankers, they implicitly agree. They implicitly agree on one particular
Amount.
value,
Mm-hmm.
value, and then they proceed further. After approving OTS, it goes as per the condition prescribed as per the OTS. So once it is approved, then the account become the standard account, right?
Right.
It become a standard account. So if OTS is not accepted,
Then it will be defaulter, and
it will continue to be NPA.
NPA and defaulter.
Continue to be NPA. If it is
Yeah.
accepted, it goes to the next stage.
Regular account becomes regular.
Account becomes standard, right?
Hmm.
Now, see, now if you can connect this particular OTS thing with the pre-pack. In fact, pre-pack, I have to say, it is kind of an hybrid. It is kind of an hybrid solution or system or process, whatever we call it. Okay, it is an hybrid process whereby the OTS and CRP, okay, like just like an LLP, limited liability partnership. Limited liability partnership, as you all know, it is a hybrid of partnership firm and company. It also have a characteristic of the partnership firm, also have a characteristic of the company. So that's why it's called limited liability partnership firm. So it has got a limited liability, which is carved out from the Companies Act, and also it has got a character of profits and other benefits, just like a partners how they have, right, from partnership. So it's called limited liability. It's a kind of a hybrid. Similar way, pre-pack, it is a hybrid, wherein it takes the character of the OTS, and also it takes the important ingredients or elements of the CARP, and have a process called pre-pack. So therefore, before getting into some process, the bankers who lend the money, they will aware that what they are going to accept. What is going to be their return of the default. What is they are going to regain, recover from the company or CD. So they will aware with that understanding, they are moving forward. Whereas in CRP, it is not so. You all know that in CRP, things are totally different. The default take place. Section 7, 9, 10, you all must be knowing that, 7, the financial creditors moves application. 9, OC moves in application. 10, CD itself moves in application. Okay. Now, why this pre-pack has to come? Fine. You give a flexibility of both OTS kind of arrangement and also in a flexibility or also in a process, a disciplined process of CR. We can call it what are the disciplined process that has been inculcated, introduced in the Insolvency Bankruptcy Code. Okay, that process. And it is a combination. Okay, and best part of OTS and the CRP has been carved out and they made this a pre-pack. Why this pre-pack is done? See, friends, now if you see pre-pack, the whole concept, why it came. In fact, we have to only relook and we should look back the period when this pre-pack has come. Before that, if you see, we have to furthermore go back to the COVID time. Can anyone here, participants, can you tell me when the limit got increased from 1 lakh to 1 crore? Any idea? From when limit got increased? Any idea? Because of the COVID, the limit got increased. Any idea from participants? The limit of 1 lakh default has been increased. The threshold limit got increased to 1 crore to initiate any CRP. When that limit got increased? Is it 21, 20 or 22? 24. Good. 24/3/2020. Right.
2020, yeah.
Yeah. So what happened? The whole COVID episode started.
We must pass the order that last time, in the interest of justice, the matter is drawn for 23rd August for further hearing. Because regular bench, if there is no representation on behalf of the petitioner on the next date of hearing, the appropriate order would be passed accordingly.
What is the interim going on?
Not the
Interim prayer. What is the interim prayer which is?
interim prayer, they have sought injunction against change in the management activity. We are holding 66% shareholding in the company.
I think Mr. Raju Lochan parallelly attending hearing. Okay. I think he is muted now. Okay, good. See now, if you see the pre-pack, as I was telling that it is a combination of OTF as well as a combination of CRP. Why it has got introduced? Because of the COVID. In fact, the impact of the COVID only made the government to think that, after the limit got increased from 1 lakh to 1 crore, then the government was, was under the thought process wherein if 1 crore default alone can approach adjudicating authority for relief, then what would be the situation of the default less than 1 crore? That means small companies. We can take it as a small companies. So that only triggered government, we should have some process in place wherein the default less than 1 crore also is really taken care of, and corporates are given that way out in case of any default less than 1 crore, or they should have a remedy. They should have a remedy to approach and see that they are recovering and reviving the company, so that the during that process, in COVID process also, And also after that, since the limit got increased to 1 lakh to 1 crore, it should not happen that the default less than 1 crore alone, no more than 1 crore alone is taken care of by the system, by the government, and default which is less than 1 crore is spared in the process. So in order to make sure that the default less than 1 crore is also paid attention. So government felt it important that there should be some process to be introduced whereby the small companies, we call it MSME, the small companies also is brought within the ambit or should be given an opportunity in case of any default. Okay, in case of any small amount default less than 1 crore. Of course, the minimum amount prescribed is 10 lakhs. So more than 10 lakhs and less than 1 crore, so that they should have a window wherein they get a relief for the default. Okay, that's the whole concept of pre-pack, wherein the pre-pack is mainly or is fully to give a relief to the MSME sector. The pre-pack is nothing but it is a relief which is targeted to the to the MSME sector, to give to the MSME sector. I'll take you through in detail in my slides presentation what is the MSME and what are the provisions that are applicable. So I would, if you have any basic things, any doubts, you can ask me, or I'll share my screen. I'll move with my presentation and other inputs. I hope till now there's no doubt. I can share my screen and move towards my presentation so that I can take you through some important aspects. Then I will take you through some detailed deliberation. Okay. Now I'll share my screen wherein, yeah. See, before taking you through a detailed presentation, I wanted you to you through a note where it will be easy for you to comprehend that why this this particular aspects. Right. I will just open the file. Yeah. Now, if you see, this is the highlights of pre-pack. Then I will take you through in detail. Probably once we understand the basics of the pre-pack, then it will be easy for us to move forward and understand in detailed manner what is pre-pack, what are the process to be followed, and how it should be, the process should be initiated, and what are the processes to be followed, and how it differ from the CRP. All those aspects we will see that we are trying to understand today before close of this session. Fine. Now if you see the provisions relating to the pre-pack insolvency process, now the pre-pack insolvency process. Just a moment. Give me little time. I Yeah, so I was getting some noise, so I thought I can tell them to stop sometime. Okay. So if you see the provisions of pre-pack insolvency process, the process per se, if you see, it dealt with in chapter 3A in part 1 of the code. Okay. You all must be knowing that it's been introduced. A new concept has been introduced wherein chapter 3A has been prescribed for this pre-pack insolvency process. The pre-pack insolvency process is available, as I was telling you, to micro, small, medium enterprises. You all know that section 54A to 54P deals with the pre-pack insolvency process. Okay. Now, if you see what this amendment provides for, the Amendment Act 2021, you all know that the process, the provision has been introduced with effect from 4th April 2021, and the respective rules and regulation have been notified and came into effect with effect from 9th April 2021. Now, if you see that what that amendment provides for, the amendment provides for the amending section 4 of the code to insert new provision to give power to the consumer to specify. This is the one amendment that has been specified. Then again, the amendment has specified section 5 to make conceptual changes whatever the definition of insertion of new definition for pre-packed insolvency process. That amendment also, it enables that amendment. So again, to amend, enable to amend section 11 to make certain changes pursuant to the inclusion of chapter 3A to in order to disentitle certain person from filing application for the, see, that's why they increase the limit from 1 to 1 crore, and also they put the condition who are all not entitled to initiate a pre-pack. Okay, we will see in detail way in subsequent slide just a while. And also, if you see, it was the amendment headed to insert a new section 11A to provide the manner of disposal simultaneously how it can be done to make sure that smooth process taking place. Same way section 33, 34 also need to that required amendment. Accordingly, it enables the amendment there. Same way, if you see that the management of corporate debtor, you have to issue a declaration for initiating the pre-packed insolvency process, and the members and corporate. In case of LLP, the partner shall pass appropriate resolution. So, what are the process to be followed? All this become an ingredients of the pre-packed insolvency process. If another important aspects of the pre-pack is that the unrelated financial creditors only can decide by vote of not less than 66%. Of course, I'll be taking you through the complete steps right from scratch, how it's the idea can be mooted and how it can be taken forward, how the application can be filed, and what would be the order. All that I will take you through in detail. But this is just to give a bullet point, so that probably I can take it at the end. But if you have idea now, it is easy for you to connect whenever I'm taking respective provisions in a detailed manner. Okay, now if you see section 54B that provides for insolvency profession to perform the duties, and we should commence from the date on which his name is proposed in the declaration and approved by the unrelated financial creditor. If you see adjudicating authority, if you see under section 54C, adjudicating authority, they can either admit or similar like CRP. Either they can admit or reject the application from within 14 days from date of filing an application under section 54C. If you see similar way, section 54D, wherein you see the pre-pack insolvency process will, the maximum timeline prescribed is 120 days, out of which 90 days time has been given to the resolution profession to file the resolution plan with the AA. Here there is a difference, where the regular normal CARP where we are handling the normal CARP, that maximum timeline is 330 days time. Whereas in case of pre-pack insolvency process, the timeline given is that its maximum is 120 days time, and out of which 90 days time is given. Only 90 days time is given to the RP to file a resolution plan, which adjudicating authority. Thereafter, 30 days time has been given to the AA to approve the plan. In case If no plan is approved by COC, then the RP shall apply to the adjudicating authority to terminate the prepared insolvency process. This is the a bullet point of the process. We will see it in a detailed way little while. Adjudicating authority then, while passing order, will declare the moratorium that we will go through in detail. Then adjudicating authority shall appoint a RP who has been suggested by the unrated financial creditor. Then RP shall cause the public advertisement. All this is process involved in the pre-pack. Then RP shall conduct the pre-pack insolvency process, and he should execute and perform his duties and powers on the management of the corporator. Here, one important difference is the management. It remains with the management of the affairs remains with the corporator. It's not like a CRP where it goes in the hands of the RP, where it will go into the hand RP only if the COC approves by 60% majority, and also required orders passed by adjudicating authority. So we will see all this in detailed way, subsequent slides. And the fees and expenses RP shall be subject to the condition under section 54F as it prescribed. Same way, if you see section 54G, the CD shall submit all claims and preliminary information to memorandum and person responsible for any omission, information or inclusion of any misleading will be liable to pay compensation to person sustaining any loss or damage. In fact, there's a separate section introduced for the penalty. I will take you through in detail, after we discuss on the process, pre-pack process. Now, if we come to the 54H, it talks about management affairs of the corporator. It should be constituted and vested with the board of directors. As I was referring that the management of the affairs of the CD, it will be vested with the board of directors. And in case of, we will discuss the situation when it will come in the hands of the RP. COC to be constituted by RP based on the list of claims confirmed by under 54HI. 54I. Okay. Then adjudicating authority shall pass an order wherein vesting of management of CD with the RP if the affairs of the corporator are carried out in a fraudulent. There is a detailed process prescribed what should be followed under section 54J to see that the order has been passed by adjudicating authority, and consequent to the passing of order by adjudicating authority, then the management will vest to the RP. Let's see in detail little later. And COC may approve, as I was discussing, that COC may approve the base association plan. That's a plan. The base plan, I was telling that, discussing about the OTS process. So what we call as OTS, that's a proposal, right? Similar proposal, their base association plan should be given by, submitted by the CD, where we call it as a OTS, and it is submitted to the bank. It's kind of a similar, thinking that the languaging is different, context is different here, wherein instead of OTS, now here is a base resolution plan. We will see in detail about base resolution plan and what is other kind of resolution plan and how it should be dealt with when the plan is presented, and what priority should be given to the base resolution plan and plan given by outsiders other than CDs. All that we will discuss a bit later. And now, if you see, COC may approve the, here you have to use the word, they very carefully use the word may approve. Okay, there is no compulsion on that part. May approve the base resolution plan submitted by the corporator if it provides for full payment of the claim of OC. This is the basic thing that the COC has to ensure. If the base resolution plan does not provide for such full payment or is not approved by COC, then the prospective or resolution applicant shall be invited to submit the resolution. That means once the COC sees, okay, the base resolution plan is not is up to their expectation, then they will instruct the RP or give direction to the RP stating that they will request the RP to move forward with the taking the resolution plan from public, means other than the corporate data, so that the COC can consider the other plans and keeping the base resolution plan, and we should be better after seeing all evaluation matrix, after evaluating and after seeing that we will discuss in detail about base resolution plan and how it can be evolved. Other resolution plan will be evolved, should be evolved by the COC before consideration. All that we will discuss in detail. And resolution plan, as I was saying, selected by the committee of Qatar, pursuant to that invitation is should compete with the base resolution plan. And the resolution plan should be approved. Here also, it is only a prerogative of the committee of Qatar that they should approve. They may approve, they may not approve. Where the base resolution plan of the corporate data is being approved, and if it does not provide for the full payment of the claim, then COC may consider dilution of the rights of the promoter in the corporate data and or provide reasons why they are still considering the base resolution plan. So if you see that the provisions of section 29, 30, which are applicable to the CRP are all applicable to pre-packed insolvency process also as per section 54K. Now coming to 54L, if an order vesting in management of corporate data, where we have seen in previous slide, as per the order of the under adjudicating authority on an application made, okay, with the approval of COC, then if you see, if an order vesting of management of corporate data with RP has been passed and the resolution plan approved by the COC does not provide for change in management or control, then AA will pass a liquidation order. This is very important. So this is very important that there cannot be a contrary stand. See, the resolution plan should provide for order vesting management of the corporate data with the resolution plan. Okay. Otherwise, and there is another scenario. I will take you through how there can be another scenario in vesting of management with the corporate data. The order of adjudicating authority approving a resolution plan may be appealed on the ground. You all know that section 61 subsection 3, and which is referred in section 54M. Then again, if you come, if you go to the provisions of section 54N, it gives a power adjudicating authority to pass an order terminating the pre-packed insolvency process if the committee of Qatar approves the such termination by vote of 66% of its voting share. I think we all know, familiar with the 66% in the CRP process, so there's nothing new for us to to understand and to think about the process, what is to be followed and how it is to be followed, because we are all since dealing with the CRP, by now must be comfortable with all this regular process that we follow in the CRP process. Okay. Now see another important provision where 54P, which talks, it says certain provisions of chapter 2 and 3 and 4 and chapter 7, chapter 2, 3 and 6 and 7 are to apply to chapter 3A for the pre-packed survey with a suitable modification. Okay, we will see what are those provisions, what are to be applicable, which are applicable to CRP, also made applicable to pre-packed insolvency process. And again, the provision provides for, the amendment provides for section 61 to provide for appeal against liquidation order or order for initiating CRP passed during the pre-packed insolvency process under chapter 3. We'll see the scenario how it comes. Then again, the amendment is enabled for 65, section 65 to insert a penalty for fraudulent and malicious initiation of pre-packed insolvency process. This is another important provision, has been introduced. As I was referring that during pre-packed insolvency process, when officer CD manages its affairs with intent to defraud its creditor or any fraudulent purpose, penalty may be imposed upon such officer under 67A. That only I was trying to say that. Section 67A. Now, if you again come to section 77, the expression to section 77 is to be omitted. A similar expression has been added to new section 77 of the code. So again, if you see new section 77A has been introduced to provide punishment of offences relating to the pre-packed insolvency process. Then by again to amend, the amendment provides for to amend section 208 to insert action taken by the RP during the pre-packed insolvency process and action taken before initiation of the pre-packed insolvency process. Now, if you see the amendments, consequent changes of section 299, 39, 240 code for enabling to to prepare to provide for rules and regulation. Of course, we are going to discuss about micro, small, medium enterprises. Now, section 240A also amended to apply the exemptions of section 29A, which is applicable for micro, small, medium enterprises to the insolvency, pre-packed insolvency process. This is the basic points. What I so far explained are the basic points, which is a crux, actually speaking, which is a crux. In fact, I wanted to discuss and deliberate the crux so that when we discuss in detail, it will be easy for you to comprehend and to see that how these things, how the process has been given under the code, and to see that section right from section 54A to 54P, what are the process procedure involved and what are the provisions are provided by the government to make sure that there is no flaw in the process followed in the pre-packed insolvency process, and also they ensured what are the provisions that are applicable to CRP is also made applicable to the pre-packed insolvency process. Now, I'll take you through my slides. Probably, I will take you through in detail about what are the provisions and what are the process in detailed manner through my slides. I thought before taking through my slide, that would be better that I can give a basic idea about what is what about pre-packed insolvency. So now we know the crux of it. Now we have to understand in depth and how the process can be followed and what needs to be understood. What should be the proper understanding to handle a pre-packed insolvency process, and what is the requirement, and what are the process and procedure to be followed, what are the forms introduced, and what are the information to be provided along the application to be made by before the adjudicating authority. All that we will see in detail. I hope, I think you would have got some basic idea about pre-packed. Till now, if you have any doubts, you can just put me across. Then otherwise, I will move forward with my presentation. Then I will quickly go through. I will take you through one important order which has been passed by our Honorable Delhi bench by President. Our Honorable President has passed an order where it is clearly narrating what are the process that they have gone through and verified and examined. What are the process that they examined before passing an order of pre-packed insolvency. And I will show you that, I'll take you through that order also before closing my session today. So then you'll have a better idea how the entire pre-packed insolvency operates, how it operates, and what are the necessary ingredients of that, and what needs to be, what we need to understand before proceeding further with the pre-packed insolvency process. If you have any doubt, you can ask. Yeah.
Serial number 6, State Bank of India 178.06.
Sorry, your voice is breaking. Hello?
45985. Facility A5. Serial number 20.
Voice is very. You have any doubt? Do you have any doubt? Is it cross-track?
Terms and conditions are on it.
So base resolution plan is given by the CD to IRP or to RP, or it is given to the FC, financial creditors, before initiating pre-pack insolvency.
base resolution plan should be given to the CD to the RP. Okay. Initially it is to be given to the financial creditor. Once commencement of a pre-pack insolvency, within 2 days time, it has to be handed over to the RP to place it before the COC.
Again,
Anyway,
right.
yeah, tell me.
Again, first it has to be given to FC.
Yes,
And
yes. FC basically has to consider. Anyway, I'll do one thing. I thought some technical side, process side, we yet to see in detail. I'm going to show you the complete process, step by step, what needs to be followed. Okay.
right.
I thought some technical side, if you have any doubts, what is pre-pack and CRP and other the technical side, then we can discuss and we can move forward. And steps and process procedure, I told you, more than 100 slides I have. I will take you through step by step. After finishing my, while closing my presentation, probably you will have a fair understanding. Probably then I'll take up your questions on process and procedures. Whatever I am missing out, probably we can try to cover it up there. Fine. Then going forward now, as you all know that, now I'm going to take the whole thing, what we discussed in nutshell. I'm going to take you in a detailed manner. Okay. Now we can discuss and deliberate whatever practically we are facing or how the process are taking place or how it should take place. All that we can probably deliberate. And if need be, our difficulties also we can give to the our forum ICSA and IIP Institute. So they will escalate and they can give solution to that. Probably we can also suggest some improvement on this also if need be after deliberation of pre-pack insolvency in this session. Now, taking you through in detail. Now, if you see the origin of the pre-pack insolvency resolution process, it starts with the constitution of the subcommittee of the Insolvency Law Committee, ILC, to structure the PPIRP framework. Now, if you see, on 31st October 2020, ILC designed a detailed framework. Then what happened? In 8 January 2021, MCA invited a comment from public. Then after that, if you see, on 22nd January 2021, it was the last date for submission of for the comments. Then 4th April, the ordinance passed introducing the PPIRP, CIRP, Corporate Insolvency Resolution Process, PPIRP, Pre-pack Insolvency Resolution Process. We will call PPIRP only, we have to call. Okay. Now, the ordinance passed introducing the process of PPIRP on 4th April 2021. Yes. Now, if you see, why the process which we are discussing earlier, I was putting this particular question, and one of our friend also gave this date correctly, 24th March. Earlier, why this whole process triggered, means this whole idea triggered in the mind of the government. What made them to bring this concept called the pre-pack insolvency?
It is basically to give benefits to the MSME, because MSME, they don't want to, the procedure for MSME shall not be so rigorous as in the case of other corporates.
Yeah, and and also the minimum amount default, as I was referring that, the minimum amount of default got increased from 1 lakh to 1 crore effect from 24/3/2020. So what happens with this increase? If any default less than 1 crore will not have any option. That means mainly the MSME will get affected. The sector, MSME sector, that's the reason why they were particularly ensuring that 10 lakhs limit, because the minimum value, we all know that we were tuned to file an application when there's a default of 1 lakh. Because of COVID, the government thought that 1 lakh is not a value at all. And I should not, a multiplicity of cases should not be there. Just because of 1 lakh default or 2 lakh default and all, we should not enter because of the COVID and because of the challenges faced by the courts and also government. They thought that we should reduce. At the same time, we should also give a window, benefit, a legal window whereby the MSME is taken care of. That means the default lesser than a crore also is taken care of. That's the main idea of introducing this particular concept of prepack insolvency process to MSME. It's not for others. It is only to MSME, not for others. So we can easily say that the prepack insolvency resolution process is applicable only to MSME, and CERP process is applicable to everyone. Okay. Now, if you see change in definition, also you all know that MSME, accordingly the definition also has been changed, and there was change took place in the provision whereby the enterprise is invested in plant and machinery up to 50 crores and turnover up to 250 crores has been brought within the ambit of medium enterprises. I will give you in detail about MSME, and so these are the basic format which is going to really make use of prepack insolvency. MSME is a format which is going to make use of this prepack insolvency. So it is better to penetrate into the understanding of prepack insolvency. The basic thing that we need to understand about MSME, because it is applicable only to the MSME. Now, if you see the manufacturing sector and service sector, so both sectors were covered. Now, if you see what is MSME, now they made it like investment. Okay, they gone by now investment. They altered to see that only by taking a criteria of investment, okay, in the plant and machinery and the turnover. With this criteria, the government wanted to specify what is medium, micro, medium, small, medium. Okay, so if it is a micro, if the investment in plant and machinery is not more than 1 crore and the annual turnover is not more than 5 crores. In case of small, the investment in plant and machinery or equipment not more than 10 crore, and in case of annual turnover not more than 50 crores. In case of medium investment in plant and machinery is not more than 50 crores and annual turnover is 50 crores. Now, an important thing here you can try to understand it here. What is that? To easily remember, between micro and small, what you have to do is that, see, here you have to multiply by 10. If we multiply by 10, what is applicable to the micro, then we can arrive the small. So multiply by 10, micro is investment is 1 crore, for small it is 10 crore. Same way multiply by 10, annual turnover which is 5 crores, not more than 5 crores, here it is 50 crores. Same way, coming to the medium, instead of 10, you have to multiply by 5. If you multiply by 5, so 10 and 5 we should remember. We have to remember 1 crore and 5 crore in micro. Then after that, it is only a multiplication process to understand small and medium. Multiply by 10 and then from small to medium, multiply by 5. So we can get the number of 50 crores and 250 crores in case of medium. Okay. Now, what is this mandatory registration of Udyam? Anybody have done this Udyam registration? Anybody have come across this? Any of the participants? Any idea? What is this Udyam registration? Udyam registration is nothing but a registration to deem it as a MSME. That's to avail the benefit of MSME, they have to mandatorily register itself as a MSME in the Udyam registration portal. Okay. So any person who intends to establish any micro medium, or small, medium enterprises may file Udyam registration online in Udyam registration portal based on their self-declaration, based on certain documents that they have to upload. Okay. Who can register as MSME? Who and all can be MSME? Just an overview. Who can be? Because MSME, we should not restrict ourselves that only this can be MSME. But who can come under IBC is altogether different. But who can be MSME? All these categories can be MSME: proprietor, HUF, partnership fund, OPC, LLP, private company, limited company, producer company, AOP, cooperative, and all can be MSME. That means in MSME it is very open. It doesn't restrict the format of entity. So that means any MSME, any person register himself as an MSME and get Udyam registration done, they become eligible for pre-packed insolvency. It is, if you see that, as I was telling, that registration of Udyam registration appears to be mandatory, whereby they made it specific in the provision that the person should be they should have the category of a MSME specification. They said who specified as MSME. Okay, though the provision says specified as MSME, the provision doesn't say registered as MSME, but still, probably when we are filing, they may be insisting for registration. If they go by specification, then what are the limit I told here? These are the specifications. So then they deem it as a micro, small, medium. They go by specification. If they go by registration, that mandatorily has to be registered. Now, what is the registration of how it can be done by existing enterprises? These are the small points which I thought I can share to you for the benefit who is already there and who want to do existing registration again on Udyam registration portal after 1st July 2020. So these are the process that they have to follow. Coming to pre-pack insolvency resolution process. Now, these are the basic things that one should understand in the pre-pack. Who is financial regulator? I know we are all aware, you must be aware of all this concept, but still, just to again reconfirm that pre-pack is not something different, totally different from which we are already in practicing, means which we already know as a CRP. We need not to think that the pre-pack insolvency is completely a different order. No, whatever the provision, whatever the context that are related to the CRP, same context, same provision is as equivalent applicable to the. We will see in detail what are those thing applicable to the pre-pack also, the same way how it is applicable to CRP. So these are the concepts which are common for both CRP as well as pre-pack insolvency. Okay. How the pre-pack insolvency, what is the framework, how it operates? As I was referring, telling that Insolvency Code 2016 amended by the Amendment Act 2021. Okay, then the Insolvency Bankruptcy Pre, as I was saying that pre-pack insolvency rules, same way there's a pre-pack insolvency regulation, which came in effect from rules and regulation came into effect from 9th April 2021. Now, IBC code amended by an ordinance dated April 4, 2021. Subsequently, in July 2021, there was an Amendment Act 2021 and got regularized, legalized, and the provision got introduced from 54A to 54P. What are the prerequisites for initiating pre-pack insolvency resolution? We need to understand before getting into the process called pre-pack insolvency resolution process, we need to understand what are the prerequisites for it. Because anything, there's a pre-requirement is there. In case of CRP, there's certain pre-requirement. In case of liquidation, there are certain pre-requirement. So same way, In case of pre-pack insolvency, there are certain prerequisites. What are those prerequisites for initiating pre-pack insolvency? As I was saying that it should be an MSME. One. Next, the default of at least 10 lakh rupees. Then, it's not undergoing a CARP. It should not already undergo a CRP process. Then is eligible to submit resolution plan under section 29A of the code. So these are the eligibility for the PPIRP process. Now, in fact, now one of the requirement is that the UDM registration certificate has to be attached along with the application. That's why I was telling now that earlier the registry were insisting for UDM registration certificate to be attached with the applications. Now, again coming back to the eligibility of PPIRP, that has not undergone a PPIRP during 3 years preceding initiation. That means already should not have undergone a PIRP last 3 years preceding the initiation date. Same way has not completed a CRP during 3 years preceding the initiation date. That means today we are starting some pre-pack. It should not have completed one CRP during 3 years preceding initiation, that are immediately preceding the initiation date, 3 years. Okay. So if you see importantly the provision that has not completed a CRP immediately 3 years, I said. Same way is not required to be liquidated by an order of 30. That means there should not be any liquidation order passed. This is also another important point which we need to understand. Now, if you see the approval of members, who has to approve? Either special resolution or a resolution passed at least by 3/4 of total number of partners in case of LLP. Okay. So either in case of company special resolution or in case of partnership, 3/4 of it. Now a very important portion now. Now declaration form P6. What is a kind of a declaration? I'll take you through in much more detail in subsequent slides. Now, if you see the process, there should be a declaration form P6 stating that application for PPIRP shall be filed within 90 days. No intention to defraud any person, and name of the IP is proposed to be appointed as an arbiter. This declaration should be taken from all the directors in form P6. Now, notice calling the meeting of creditors. This is another financial creditors. Notice calling meeting of the financial creditor shall be served on all financial creditors who are not related parties to the corporate debtor. It's very important. The entire pre-pack insolvency makes it clear that it only looks for approval or nod of only unrelated financial creditors. So related financial creditors cannot be involved in the approval process or in the implementation process of the pre-pack insolvency process. So 5 days notice shall be given unless short notice is agreed by them, all of them. Date, time, and venue of the meeting shall also be mentioned. Meeting may be held either in physical or electronic mode or combination of both. Okay. Now, what are the enclosure for the notice calling the meeting of financial creditor? The enclosure for the notice calling meeting of financial creditor, list of creditor in form P2 with the name of creditor and claim and percentage of claim and category of creditor, whether related or unrelated. The declaration has to be done. Declaration of directors and partners in P6. A copy of the special resolution and our approval, partners approval resolution. Then base resolution plan has to be provided. Other and information, whatever other may be relevant. Now, if we see PPIRP can be initiated only by CD himself. CD itself, if the company prefers to initiate, then the CD itself can initiate the PPIRP prepacked IRP process, but approval of financial creditors is must. When there is no FC financial creditor, where all FCs are related parties, then meeting of OC who are not related parties shall be convened. So approval for initiation of PP IRP shall be provided in form 24, in form P4. Approval for initiation of PP IRP shall be provided in form P4. Now, appointment of resolution professional by financial creditor. The financial creditor who are not related parties of the corporate debtor and have not less than 10% of the value of total financial debt may propose the names of IP. That means initially the financial creditor who are not related parties and not less than 10% in value they have to propose the name of the insolvency professional. Terms of the appointment of insolvency professional shall be in form P3. What are the fees payable to him for performing the duty? Fee payable to him and expenses to be incurred by him for conducting the process. Fee payable to him and expenses to be incurred by in case of management of corporate debtor when it is vested with him under section 54. Yeah. Now, coming to the duties of insolvency. What are the duties of insolvency? Post approval of financial creditors. It's very important. Post approval of financial creditor, the insolvency professional shall prepare a report in P8. What kind of report he has to prepare? He has to prepare a report confirming whether CD meets the requirement of 54A. 54A is nothing but taking declaration, all that initial process. Whether base resolution plus conforms to the requirement referred to in class C of subsection 4 of 54A. So this also needs to be seen. Now, what is again the consent in form P1 stating that he is not subject to any disciplinary proceeding by the board or the IP agency. He do not suffer any disability. Very important. Similar thing which we are seeing for CARP, same thing. He is eligible to be appointed as the RP. So another important thing we have to see. And he shall make the disclosure in accordance with the code of conduct for the IPs set out in the regulations. Okay. Now, the IP shall be an independent. Okay. IP shall be independent of the corporate debtor. Okay. When he will be considered as an independent of the corporate debtor? When? What is the situation? Then if he is eligible to be appointed as independent director under section 149 of CA. For appointment of independent director, what are the provisions of section 149 Companies Act 2013 provides for? Same has to be seen to deem, to recognize, to reckon a person to consider as independent of CD. That's why they are called independent director. He is not related party of the CD. He is not an employee or proprietor or partner or firm or auditor or second auditor or center of the CD. So he should not be there in any of this position in last 3 years or even of a legal or consulting firm, but had any transaction with the corporate debtor amounting to 5% or more of a gross turnover of such firm. Now, choice of authors in case of class of creditors in committee. Okay, RP appointed by financial creditor shall examine the list of creditors in form P2, ascertain the classes of creditors, if any, ascertain insolvency professionals to represent each class of creditors. Each class of creditors. Now, if you see in that, this is a process which we follow in a CRP, same thing we are following here. The RP shall identify 3 IPs to represent class of creditor who are not related party, having their addresses, eligible to be appointed under the code, willing to act as an authorized representative of the creditors. Same way, upon identifying eligible IPs, the consent in form P5 shall be applied. Same way, choice of creditor shall be sought to choose. Yeah? And if you see that one IP, creditor shall communicate the choice within 3 days. The IP who is having highest choice shall be chosen to act as no representative. The name of selected IP along with this consent shall be sent by RP to the corporate debtor. So RP only will send the information to the corporate debtor. This is very important point that we need to understand. So cessation of duties of the insolvency professional. Duties of IP appointed as RP in the meeting of financial debtor ceases if corporate debtor fails to file an application with the BPRP, because the CD has to necessarily file an application within 90 days. It's very important. Within 90 days, or the application filed is rejected by itself. In both the cases, okay, the duties of ARP, the duties ceases. The ARP, the RP's insolvency professional duty is ceases. And the application, in above cases, the fee payable to RP shall be borne by corporate debtor themselves. Now, prepare the insolvency process, resolution process cost. Same way what is there in almost in the CRP, same thing has been follow. The amount of any interim finance, the cost incurred in raising such finance, the fees payable to any person, or any cost incurred by RP in running the business, any cost incurred at the expense of the government. Now, these are the routine things which we follow even for CR. Whatever we are following for prepack, the same thing only in prepack also we are, whatever we are following for CRP, same thing only is followed for prepack also. And fees payable for authorizability out of pocket responses. And they should, the CD shall maintain a separate bank account with such amount as may be advised by the committee from time to time, and shall be operated by the RP to meet his fees and expenses incurred. And what next? These are the preconditions. What are things to be seen before proceeding further with the CRP process? Prerequisites of the conditions are met. Whether all the conditions are complied with, we have to see. Approval of financial creditors is obtained. Yes, obtained. Appointment of RP is made. Yes. Authorized representative for class of creditors chosen. Yes. Now we are moving to the application to initiate the prepared insolvency process. Now, how would application to be made? Application to NCLT shall be made in Form 1 through online mode. Fees is 50,000 rupees. In case online facility is not available, all this is a routine now instruction is given by the NCLT's registry, and all this thing has to be necessarily to be followed. Now, what are the attachments to Form 1 for making an application to NCLT for initiating PPIRP process? What are the things to make? Non-affidavit stating that CD is eligible to submit plan. That's the first thing you have to make sure. One, affidavit. In case of financial debt, the record of default obtained through information utility. Any other document in order to prove the existence. So it's the next important. Then again, another important. In case of OC, copy of invoice demand served on the OC, or copy data, or record of default, or any document in order to prove the existence, the amount of default. Now, approval of creditors for appointment of proposed RP as set out in P3 has to be. The declaration obtained from directors and partners in P6 also to be part of the Form 1. The copy of special decision and resolution of the partners should be part of the Form 1. The approval of financial creditor in Form 4, P4 should be part of the Form 1. Consent of IP to be appointed as RP in Form P1 also to be part of the Form 1. Okay. Now again, report of IP proposed to be appointed as RP in P8, in form number P8. Now, declaration regarding the existence of any transaction of CD that may be within the scope of avoidance transaction under chapter 3. So same thing now. Therefore, PPRP also. So same we have to have a declaration. Audited financial statement of CD for the last 2 years. I'll take you through an NCLT order where it clearly says how the application is filed, what are documents is attached, and how it has been dealt with by them. Then what is the relief that they are granting, all that is, I'll take you through in a detailed order of our Honorable President espoused one of the PRP order. Okay. So provisional financial statement for the current financial year made up to P6 declaration class F. This also should be made part of the Form 1. Consent of IP received in Form 5. Willing to act as an authority for any class. The copy of the relevant books of accounts of the corporate debtor, providing that evidencing the default to the creditors. The copy of relevant extract and constituted documents. All this is a routine thing that we do. Wherever the context of the dispute, we need to suppose it's a case between the employee and the corporate debtor. Then employment agreement we need to. So similarly, depending on the nature of the dispute or issue, we have to see accordingly the documents are attached to the applications. Okay. Now, copy of authorization provided by the corporate applicant to the person making the application on his behalf. Then again, copy of authorization provided to the person resident in India to accept the service. So all this is mandatory. We need to provide all this. Copy of latest and updated within certificate. Proof of investment. And copy of certificate of registration charges in case of secure creditor. And also proof should be given that the application fee has been paid. And that a copy of application has been served to the IBBA. That also we have to say that proof that a copy has been served to IBBA. Application to NCLT. Attachment to Form 1. A statement of affairs made up to date not earlier than 14 days from date of application, including the following documents. What are those? Okay, what are those along with the statement of affairs? A list of corporate assets and liability. Particulars of claim and its amount, and of how and when security was created, if any is there. Name and address of the financial creditor and operating creditor of CD with the amount due to each of them. Particulars of the debt of the corporate debtor. Whether any guarantee is there, all this point has to be given. Then copy of the application in Form 1 shall also be served to the board IBBA by registered post or speed post or electronic form before filing it with the NCLT. This is very important. Action of the NCLT after receipt of the application in Form 1. Now, I'll take you through what are the process that NCLT should follow after filing an application. After filing an application, that means Form 1 with the NCLT, the adjudicating authority has to see whether the application is complete in all respects. If application is complete, admit within 14 days. If it is not complete, then give notice to applicant to rectify. Same thing what we used to follow in CRP, almost same thing only here followed. Orders of NCLT upon admission of the application. Then commencement of PPRP. Then moratorium. This alone I will show you in the order how it's provided in the order of the Honorable NCLT by Honorable President. I'll show you all that. What are the basic ingredients that the order should provide for. Okay. So commencement of PPRP, moratorium, and public announcement. So commencement of pre-pack insolvency resolution process. What is the time frame for completion of PPRP? Commences from the date of admission by the NCLT to be completed within 120 days. Then RP to submit resolution plan within 90 days. If no plan is approved by COC within 90 days, RP shall file to NCLT for termination. That means there should be a plan. Otherwise, the RP should file to NCLT for termination. It's very important. So appointment of resolution professional. how it happens. So RP is already appointed by the FC, as we discussed that FC already proposes the appointment of RP, and RP, he only follows the process and what are the basic things. He prepares a report, all that is doing. Then if there's any dispute proceeding against him, then IBB will refer, give, suggest, recommend a person to whom to be appointed as a RP. Otherwise, the same RP will be confirmed. Duties of resolution professional. What are the duties of resolution professional here? So he has to see that he is confirmed the list of claims submitted by CD in form P10. Very important. Then inform the creditors regarding the claim as confirmed by IB in the manner as prescribed. Here we have to understand prescribed. So if it is if anything is prescribed, by whom? Can be prescribed by ministry, means central government. Okay, if it's specified, then it can be by the regulator. So it is by Insolvency Bankruptcy Code. Okay. Now maintain an updated list of claims. Then monitor the management of affairs of the CD. It is very important. Here, resolution professional under in PIP IRP process, resolution professional is not vested with the management. How, unlike in CRP process, the resolution professional vested with the management, and the board's power is suspended under CRP process. Whereas in case of PPIRP process, the resolution professional is not vested with the management, and he can only monitor the management of affairs of the CD and inform COC in the event of breach. In the event of any of the breach of obligation by the board of directors, partners, as the case may be, he has to inform the breach to the COC. So here under PPIRP, the RP's role is to monitor the management. Monitor the management of the affairs of, not to manage the affair itself. It is a case where in CERP, the RP is expected to manage the affairs of the company itself. Whereas here, it is sufficient, or he is not permitted to manage the affairs. He is only permitted to monitor the management of affairs. So very important. When he is permitted, or when he will be obligated to manage the affairs, we will see in subsequent slides. Okay. Now, what are the duties of the RP? What are the other duties? As usual, constitute the COC, how we do in CRP, and convene, attend all the meeting, prepare information memorandum on the basis of information memorandum, and file application for avoidance transaction, as just we do in under chapter 3 of the code, or fraudulent or wrongful trading, section 66, of the IBC, chapter 6 of the code. All this same thing has to be carried out as duty of RP in PPIRP also. RP also shall also preserve the physical as well as electronic format. Shall be maintained as per the retention schedule as required by IBA and consulted with the IBA. The RP shall file such form on electronic platform as required by IBA in consultation with the respective IPA. So this is very important to understand. What are the powers of RP in PPI? Very another important thing to understand. To access all the books of codes, records, and information available in the CD. Access the electronic records of the CD from an information utility having financial information of the CD. Access books of accounts and records. All of the government authority, statutory authority. This is very important. In fact, even in CRP also, the RP has power to access the books of accounts and records available with the government authorities. So the RP can write letter to the government authority and say that, no, I wanted to access the records which is available with you. This is the power given under the CRP provisions. And attend the meeting of the board members and board of directors and committee of creditors, and appoint accountant, legal, and other professionals. Okay, and just like in a CRP provision, who is not registered with regulator, what are the restrictions? What are the who shall not be professional, that same thing which is provided in the CRP regulation. A person who is not registered regulator cannot be, and related party of the CD, an auditor of the CD, anytime during 5 years cannot be appointed. A partner of the insolvency professional entity of which a RP is a partner, relative of the RP, all this is are not permitted. Then collect all information of the CD for determining financial position and existence of any transaction that may be made. So these are the basic things which we follow in CRP process. Same process has to be followed even in case of PPIRP. So here, in fact, it also includes a business operation for previous 2 years from date of pre-packed insurance. That's very important. There's a look back period of 2 years, how we see in the CRP. So coming to the resolution professional also shall have access to books of CD held with the members, promoters, partners, directors, similar like CRP, professional advisors engaged, depositories of securities, registries, then other counterparties of the corporate data. Same thing which we used to have in CRP. Same way under section 19 where we see file an application, same way the cooperation of the personnel of the corporate data to be given to the RP for PPIRP, who is involved in the PPIRP. So the financial institution maintaining the accounts also should furnish all the available details. The personnel of CD are promoted and they should extend all their assistance. Same way how we do in CRP. Otherwise, we can move an application and see that we are getting the cooperation. And similar way how we have a moratorium under the CRP process, same way, similar way, exactly the same. The same moratorium is applicable not only under CRP, same thing is applicable in PPIRP also. I'll take you to the order also. I'll show you how it is there. What is the effect of moratorium? The same moratorium, what is the effect that has got in CRP? Same effect that got in PPIRP also. Of course, the moratorium, certain financial sector regulations don't apply. You all know that there's a circular for that. And now, next to that, the public announcement. Can we break for 5 minutes, man? 5 or 10 minutes? Otherwise, the participants should not get
Take break
post.
for 5 minutes.
Yeah. Okay. See you again in another 5-10 minutes. Okay, we'll start again. Okay. See, now coming to the public advertisement. Okay. In fact, this we used to do in CRP process itself, sir. But in case of PPARP, it is within 2 days, commencement of PPARP, there should be a public announcement where the RP shall make it in the format of form F9, and it should be sent to every creditors listed in form P2 and information utility to be published on the website of the corporate debtor and IBBA. Here, it is very important. If you see, in normal CARP, we always give in a newspaper, okay, where one in English language and the other one in a vernacular language. We supposed to give where the register office of the corporate data is there and business of the corporate data is. Here, same thing is not there. Actually, if you see here, the public announcement, we wanted to, the rule provides for, the provision provides for public announcement only in the website of the corporate data and in the website of the IBBA. So this is another important, aspects that we need to understand. Comparing to the CRP process, here the process here is need not to give in a newspaper. It is sufficient if we give it in the website of the corporate data and website of the IBBA. What are the content of the public announcement? Of course, this also is another important aspect. We have to say that in CRP process, there is no specific thing that what should be the content of public advertisement. But here they gave a clear format, kind of a thing form. What are the content? Name of the corporate data, former names if changed in last 2 years, then date of incorporation, then authority which corporate data is incorporated, SIN number, and the register office address and principal office. Then what is the pre-packed in those the commencement date, and registration name and registration number of RP, and address and email of the RP, and address and email for the correspondence of the RP, and the date from which the list of claims will be made available. That also is very important aspects that we need to understand. Now, duties of the corporate data upon commencement, upon commencement of PPARP. The immediate thing is within 2 days of commencement of PPARP, submit a list of claims along with the necessary details to the RP. Same way, within 2 days of commencement of PPARP, preliminary information memorandum containing information relevant for formulating a resolution plan shall be submitted to the RP. So this is a very important thing. So list of claim of creditors and preliminary information memorandum, both should be given within 2 days time of commencement of PPARP. Yeah. Then how to ascertain what are the things to ascertain? So ascertain the list of claims of the creditor within 2 days of commencement of PPARP. The CD should submit in form P10 to the RP with what are the details? Name of the creditor, identification number of the creditor, number of the claims, amount of claim, nature of claim, whether related party or not, amount of the contingent claims. Okay, these are the points that we want us to consider. Okay, let's try to understand what are the category of creditors. You may be aware of the category of creditors when you are handling CRP cases, but just for the easy reference, that secured financial creditor belonging to any class of creditor, unsecured, then secured financial creditor other than the financial creditor belonging to any other class, then unsecured financial creditor other than then operation creditor, workman, employee, government dues, all are OC, and OC other than the workman, employee, government dues. Then other data. Same in waterfall mechanism, what are all covered under section 53 of IBC code. All these categories are stated here. So ascertain the list of claims of creditors. RP shall confirm the claims. Then RP shall inform every creditor on the claims and seek objection. The creditor may submit the objection along with the proof within 7 days. Then he should, RP may call for such as the detail, what are the proof he may have. Then he can update the claim also. Then RP shall maintain the list of claim in form FP10 and update whenever it is required. Now, maintenance of list of claim. Coming to the maintenance, RP should maintain the list of claims in form P10. Now, what are the conditions? Same thing which is there in CRP, same the case for the PPRP also, should be made available for inspection by the creditor, members, partners, displayed on the website of the corporate data and filed with the IBB on the electronic platform and presented at the meeting of the committee as and when updated. This is another important aspect we need to keep it in mind with respect to this claim. Then preliminary information memorandum. CD shall submit the RP. Very importantly, here if you see, corporate data shall submit to RP the preliminary information memorandum within 2 days of commencement of PPRP. This is very important aspect that one should understand. Should contain the relevant information necessary, whatever for formulating the resolution plan. So contents of the preliminary information memoranda are similar, almost what is required for the CARP, and the process is same. Here the size alone is small. Otherwise, the entire process and the methods, all what needs to be followed, all are almost similar and same, except few changes which is applicable only to PPRP, not to the CARP. Assets and liability with such description as are generally necessary, sustaining their values. So then the latest annual financial statement, then audited financial statement for 2 years, then list of claims contain name of creditors and amount of claim, particulars of debt due from and or to the CD with respect to related parties, details of the guarantee that have been given in relation to debts, names and address of the members holding 1% stake in the CD, and details of the material litigation and an ongoing investigation proceeding initiated by government, number of workers and employee, liabilities towards them, and any other information may be relevant. So now RP shall finalize the information memorandum and submit to the members of committee within 14 days of PPRP commencement. It's very important. So within 2 days, the corporate data has to provide. Then within 14 days of the commencement, the RP should make sure he is submitting to the members of the committee. Prior to such submission and undertaking to be obtained from member, we take similar undertaking in CRP also, where confidentiality to be maintained. Okay, and should not be used for undue gain and other purpose. So in case of defects in list of claims and preliminary, and or in case of a preliminary information memorandum, what are the other aspects to see? See, if any person has sustained any loss as consequence of omission or misleading information in the list of claim or preliminary information memorandum submitted by CD. Here, one important thing is, in normal CARP process, the list of claim, of course, the detail RP will be requiring a detail from promoter, but promoter is not duty casted upon to the promoter to give within certain days under normal CARP list of claims. It is a duty of the RP only to collect, IRP only should collect the detail of the claims or creditors and claims. In certain cases, promoters will not give also, may not cooperate to give also. But here, the duty itself is casted upon to the corporate data to provide within 2 days a list of claims and also preliminary information memorandum. Whereas in a normal CARP, we do a preliminary information memorandum will be prepared by IRP itself. Okay, IRP and RP only by preliminary information memorandum. But here the duty is casted upon to the CD to provide the preliminary information memorandum. This to that extent the RP is relieved with this tension of getting all the detail, and consequently there will be obviously there will be non-cooperation from few promoters. Few will cooperate, few will not cooperate. So that burden also will be in the shoulder of the RP only. But in case of PPRP, since the duty is casted upon the CD, so at least CD will cooperate. They will be cooperating. They will be providing, because after all, it is for their revival. So they have to cooperate. That's why the duty is casted upon to the corporate data. Okay. So after getting this list of claim and preliminary information memorandum submitted by CD, Suppose, relying on that, if any loss or damage, any consequence from omission in the material information, okay, then who is responsible? Every person who is a promoter, director, partner at the time of submission of payment information memorandum or an authorized submission of information memorandum shall, without prejudice to 77A, that means 77A, there's a separate punishment for offences has been introduced for related to pre-pack insolvency. Apart from that, okay, without prejudice to section 77 of the code, shall be liable to pay compensation to every person who has sustained such loss or damage. It's a very important question, whereby in PPARP, there's exclusive provision whereby the promoter or the corporate debtor is made responsible to compensate for the information, for the wrong information or misleading information supplied by the corporate debtor. It's a very important provision. So that since it is only for their revival, the entire process is kick-started. So they're supposed to give a correct and proper information. So that's the reason the law, expects the corporate debtor to be proper, and correct in whatever the information they are furnishing. Failing which, they may be ending up with the paying of compensation to the person who has sustained any damage or loss because of the wrong statement or misleading information. Same way, no person shall be liable if it was submitted by corporate without his knowledge. That is different. That exclusion always there. So here another important thing, subject to section 54E, declaration of moratorium and public announcement. What is that 54E? It's a moratorium public announcement. Any person who sustained damage, as I was telling in a preliminary information memorandum, shall be entitled to move to a court having jurisdiction to compensate for such loss. So there's a specific provision for approaching, court to seek a compensation for such loss or damage. So there's a specific rights given. Therefore, the court will entertain and they may award the compensation also. Yeah. Now if you see another provision, since the management of a remains vested of the board, even after coming, the board of directors shall make every effort to protect and preserve the value. So here, the responsibility is casted upon to the board of directors, whereas in a normal CRP, the responsibility is casted upon RP to make sure he is endeavoring to protect and putting every effort to protect and manage the operations as a going concern. And the promoter, member, personal partner, they should exercise the discharge the contractual statutory rights and obligations in relation to the corporate debtor and subject to the provisions of Chapter 3A, which is talking about PPIRP. Now again, restriction on the powers of the corporate. What are the restrictions? The affairs shall not be managed in a manner prejudicial to the debtor and fraudulent manner. Though here, if you see, unlike a CRP, normal CRP, here the management is vested with the same board who is managing the show before this PPIRP. Therefore, now the responsibility is casted upon to the same management, same board, that they should make sure the affairs are not, managed improperly or in a manner prejudicial to the creditor or in a fraudulent manner. Then they will end up facing with the punishment. Here below, action can done only with the prior approval COC. What are those actions? Transaction above certain limit threshold can be decided by the COC. And any other matter as there was COC not covered in 28, because 28 already requires certain approval, certain items, certain matters which requires approval of committee of creditors. So if you see that what are the mandatory items that require approval of creditor by 66%, one is raising any interim. This is not applicable to normal CRP also. Raising any interim finance in excess of the amount as may be decided by the committee of creditor in that meeting. Okay. Create any security interest. Change the capital structure, because these are very important. Either altering the liability side or altering the capital side. It is altering either one. So that's why it requires 66% of the approval. Record any change in the ownership of the interest. And give instruction to the financial institution, maintain the accounts. So these are the matters which need 66%. Same way, undertake any related party transaction, amend any constitutional document, and delegate any authority or any other disposal of shares, make any change in the management of the corporate debtor, transfer rights, financial debts or operation debts, otherwise than in the normal course of business. These are things which we normally see in the normal CER, the routine CRP matter. Same thing is here applicable. Make changes in appointment of terms of contract of person specified by COC. Same way, any of the changes in the appointment terms of contract, statutory auditor and internal auditor. So, any of the above action taken by RP without a policy shall be void. So that means these are the matter where RP should make sure he is getting nod of COC by 66%. COC may report to IBA to take action against such RP if it is not properly followed by RP. Report. This is the report of by corporate debtor. What is this? The corporate debtor shall, in consultation with the RP, should prepare a monthly report and forward to the members of the committee. So here another, it is little different from the normal CRP where in a normal CRP, the board is suspended. So there is no question of report to be prepared by corporate debtor. But whereas in PPIRP, the entire responsibility of managing the affairs in a proper manner and preparing a report, a monthly report, and forwarding to the members of the committee, the duty is casted upon only on the corporate debtor. So this is a very important responsibility. That means they are only given responsibility to see that during the period of PPIRP, the corporate debtor is not indulging into any untoward, any illegal activities. So that's why the code ensures, the provision ensures the corporate debtor is given a responsibility and corporate debtor is made responsible to see that if something goes wrong, they are responsible for the action, for the inaction or action. Now if we see that, what is the monthly report provides for? The details of legal proceeding having material impact on business of corporate debtor. Details of the key contract executed during the report period. And what are the details that affects material impact on the business of the corporate debtor? Okay. Now these are the things that in a report should be given to the committee of creditors. Let's see what is the committee of creditor, how it operates. Yeah. So now how committee of creditors comes into picture, how it operates, how it operates. Within 7 days of commencement of PPIRP, the RP shall constitute COC based on the list of claims confirmed. Now, formation of COC, the committee of financial creditor, committee of operation creditor. In case of there is no committee of financial, committee of operation creditors. So in case of committee of financial creditors only, the COC shall comprise only all financial creditors. Same thing which we used to see in the CRP, almost similar thing. Where a financial creditor owned two or more financial creditor consortium shall be part of the committee of creditor, where any person of AFC as well as OC, such as then to the extent of financial debt, they will be part of the committee, where OC has assigned legally transfer any obligation to a financial creditor, then assignee or transfer shall be considered as a OC. Okay, so the color should not be changed to that extent. So that's why they are trying to curtail that. Where the terms of financial debt extended as part of consortium arrangement, and then same thing how we follow in the normal routine CRP. Where a financial debt is in the form of security deposit, then also they will be part of the COC committee. Then voting right for the related party of the corporate debtor. A financial creditor or authority of financial creditor or IP, okay, appointed to represent the creditor, all are financial creditor only. If it is a related party to CD, they shall not have a right of representation party to vote. Same the case which is there in the in normal process also, normal CRP also. Unless it is a financial creditor related by financial sector, because it is exempted by way of notification, it is exempted. If it is related party of CD solely on account of conversion or substitution of debt into equity because of that category. And same way, voting by authorized representative of the financial creditor shall not act against the interest of the financial creditor. he shall always act in accordance with the prior instruction. Then the shall way, the representative shall cast vote. If he represents the several FC, then same thing, what is followed in the process followed in the CRP, almost same process only is narrated here, same process only stated here. And committee of corporation data, in case there is no, where the CD has no financial data, or where all FC are related parties to the CD, then he or she, there's no other option, shall be formed with the operation data being not related to the corporate data as below. The same thing what we follow in a CRP process, what the same provision is applicable, what is applicable to CRP. Voting rates of OC, what is followed, the member shall have voting rates in proportion to debt to the creditor, debt represents with the total debt. And total debt, as you all know, is sum of total debt due to the 10 largest operation data forming part, the amount of gain due to the government. These are the things to be considered for total debt. Committee with only creditors in a class, means a class of at least 10 financial creditor, other than creditor with the financial debt in the form of security deposit. So that class alone, the expression, the class in creditor in a class, okay, it's a definition for that. Whether if CD has only creditor in a class and no other financial creditor who are not related, okay, the committee shall consist of only authorized representatives. In this case, the RP shall provide list of data to each class of respective authorized representative within 3 days of PPRP commencement and provide an updated list of data when the list is updated. Now coming to the electronic means of communication between the authorized representative and data. Same thing what we are following in CRP process, the same process only, here stated, where not much difference between the CRP and PPRP. So now if you see the important aspects of this, what is the right? Now, how we follow in CRP thing, here if you see no role in receipt confirmation of claim of data as he represents. He is entitled fee for every meeting of the committee approved by him in the same manner what is provided in the regulation. Same is followed in PPRP also, up to 100, 15,000 rupees, up to 1,000, 20,000 per meeting, more than 1,000 if we number of data, then 25,000. Now coming to the very important aspects of vesting of management with the RP. So here when it happens, because the normal situation, as I was referring in my previous slide, the management of CD will not be vested with the RP in a normal scenario under PPRP, because the corporate debtor who is managing the affairs of the CD, okay, the management who is managing the affairs of the CD will continue to manage the affairs even after commencement also. But when it will be vested, it's very important with the resolution provision, in which scenario. So vesting of management with the resolution provision, it happens in the following scenario. Anytime during PPIRP, if the COC resolves with the successive personal vote to vest management with the RP, then it comes in the hands of the management, comes in the hands of RP. The RP shall make an application to NCLT. It is not that simply after COC says immediately RP take control of it. The RP shall make an application to NCLT in form P14 along with the reason for such and copy of the minutes. Very important. With these things, the RP has to make application to NCLT in form P14. Then if NCLT is satisfied, it shall order the same. What needs to be, what aspect the NCLT has to see here, the adjudicating authority has to see here, affairs have been conducted in a fraudulent manner, or is there been any gross mismanagement of the affairs. If these ingredients is present, then NCLT will pass an order, authorizing, permitting RP to take out the management and custody of the affairs of the company. Now coming to the effect of moratorium. The effect of moratorium, what we seen in the CRP, same the case in case of PPRP also. There is not much difference between the CRP and PPRP here. The effect of moratorium, if you see RP consider supply of goods critical to protect the preserve. The same right how we exercise in the CRP process, the same thing, same rights we can exercise in PPRP also. The vesting of powers in the hands of RP. Now come to the stage where the powers in the hands of RP. The management affairs of the corporate debtor is vested after the order of the adjudicating authority vested in the hands of RP. The powers of board of directors partners shall stand suspended and be exercised by the RP, just like how a order passed for CRP matters, how CRP commencement takes place there. The moment the commencement of CRP happens, the powers of the board suspended. Similarly, here, upon the order of the honorable adjudicating authority, the powers stand suspended. The board power stands suspended. The officer manager of CD shall report to RP. Same the case how it is to be in the CRP, same the case here. Same the financial institution maintaining the accounts of the CD shall act on the instruction of RP in relation to the accounts. So these are things which we follow in normal CRP process. Same thing is applicable here, stated here. And the duties of resolution professional. He should act as execute the name and on behalf of the corporate debtor in all deeds and systems. Same way, he shall take such action in a manner subject to as may be, whatever the regulation provides for. He shall have authority to access all the data, which we have seen. What are the authority powers that to access the records that we have seen in the earlier slides. He shall have authority to access the books of accounts and see the government authority, which I explained that that's exclusive power given to the RP under the code where he is authorized. I don't think any other act authorizing a professional giving authority to access the government record. The RP being a court officer, deemed as a court officer, so the law provides for, the court provides the power to the extent where the RP is authorized, entitled to access the records with the government authorities also. He shall be duty bound to preserve the protect the assets of the CD. And same way, at the moment after the order passed, shall take immediate custody. How we in a normal CRP process, the RP supposed to act IRP immediately. Same way here, RP has to do in PPRP also. He has to see that he is taking immediate custody of it. And raise interim finance subject to the approval of committee as provided in the section 28, and shall file the what are the information collected with the information utility. These are the duties which he shall take custody of the assets over the CD as wherever the CD has ownership, record in the balance sheet or any other this thing. And these are the assets category which we generally take it for EN for CRP purposes. We consider all this. It's the same category which is provided for PPRP also. So I'm not duplicating, since all are IRP or must be already handling matters as IRP, RP, or data. You must be knowing about CRP. I don't want to duplicate by saying the same thing and getting and bore you. So that's why I'm saying what is much having a difference. What is having more difference than routine CRP? I'm projecting more and highlighting more than the normal thing which we keep following the same thing, which I'm skipping little. Management of operations of the corporate as a going concern. RP shall make every endeavor to protect same thing about how we do in a normal CRP process to appoint accountant, legal, other professional to contract, price in all is same, similar to that one. Now coming to the meetings of the committee of creditors. Here we see the RP shall convene a meeting as and when necessary. The request may be made by a member representing 33, same thing which we happen in CRP case. The first meeting shall be held within 7 days of the constitution of the committee. Same way, the committee has to be constituted within 7 days of the order is passed for commencement of PPRP. So notice of COC meeting, 3 days notice in writing. Every participant at that is provided. The COC may approve the shorter notice, not less than 24 hours. COC may approve shorter notice, same way if there is authorized representative also. What is the content? The same thing which we would do for conducting a meeting in a normal CRP, same the process here. Date and venue, and we keep giving option of participation to VC. All this, whatever option we give for CRP, we give same thing is stated in PPRP also. List of issues that is to be voted upon the meeting and copies of document, process and moment of the voting where comments and login ID, all that we normally do in a normal routine CRP matters as well, we follow the same thing. Service of notice through email. And here if you see subject, you should state that the name of the CD, place, time and date of the meeting is subject line itself we have to say. And maybe sent in a PDF attachment, non-editable format with link. What we follow in other normal routine CRP, same thing only here provided for. Service of notice through email, all this is similar to the CRP. And quorum for COC, same way 33% voting rate, what we follow in CRP process. Participation through video conferencing, what we provide in the normal CRP, and same thing has to be followed in PPRP also. Here the chairperson and how they have to conduct the meeting. The RP shall be a chairman and roll call shall be taken and quorum. What we follow in a normal CRP, we have to follow the same thing, announcement decision in each item, along with what are the process we are following in routine CRP. We have here in RP shall make a record a summary of decision taken and relevant register with the names of the members of committee voted for and against the decision. And circulate the copy of the records to create and the votes to all participants within 24 hours of the conclusion of the voting, which we do in CRP. And minutes within 24 hours of conclusion, the RP shall circulate the minutes to all members are authorized to see quote, and also they can see quote of members who did not vote by electronic voting system, where voting kept open for at least 24 hours from the circulation of the same thing what is provided in the CRP relation that we have to follow. Now coming to the valuation and information paragraph. This is another next aspect that we have to see. RP shall within 3 days of his appointment appoint 2 registered valuer to determine the fair value and liquidation value of the competitor. The eligibility being appointed as a registered valuer, same thing as what is provided in the CRP, same way. Following person shall not be appointed as RV. Who cannot be RV? Elected party of CD and auditor of the CD for during 5 years preceding the PPRP. Be a partner or director or relative of the RP. They cannot act, which we follow in CRP cases. What is fair value and liquidation value? The registered value shall submit to RP an estimated fair value liquidation value. What is computed in accordance with internationally accepted valuation standard after physical verification. The average value determined of situation will be considered as a fair value. So after this value, the RP shall provide the fair value liquidation to every member of the committee in electronic form on receiving the undertaking of the members, which we do in a normal CRP process. Same way resolution plan, how we deal in a CRP process, same way we do resolution plan, and resolution applicant also is the same how we deal with a person who provided a plan. Resolution plan is called as a resolution applicant. Same the case in PPRP also. The CD shall submit a base resolution to plan within 2 days of PPRP commencement. This is very important. The CD shall submit a base resolution plan to RP within 2 days of PPRP commencement date, either individually or jointly with any other person. However way we want to give, we can give. RP shall present it to the COC. COC may provide CD an opportunity to revise. Suppose the COC feels that no, it can be improved, then it can provide the another opportunity to the CD. Why don't you revise and give the base approval? Otherwise, they will go for public. The RP will go for public. The COC will give advice to the RP to go for public. Mandatory content. These are the mandatory content which we see in a normal CRP. Transfer of all part of the assets and sale of all parts of the assets, restructuring of the corporate by way of merger, amendment, demerger. Now the consolidated thing can happen in the CRP itself. Now we need to file a separate application, the section 230 for amalgamation, demerger, section 230, 231, 232 of the Companies Act 2013. We need to file. We need not to go into the separate thing. We can bring it as a part of a resolution plan. Probably after the order, we may have to, if specific order is given, that application has to be made separately as under the position of Companies Act. We have to do a separate application section 230. Then the cancellation of delisting and satisfaction and modification. Now mandatory, these are the mandatory content of the plan. Okay, what are the mandatory? What is provided in the normal CRP? The same the provisions have been provided in the PPRP also. These are the mandatory content we generally see in normal CRP. Routine CRP, we see all this mandatory content. Same thing has to be verified in the PPRP. These are the content which is really fulfilling the requirement. The resolution plan really fulfilling the requirement of the details which is to be provided in the resolution plan. The RP should make sure that is ensuring and verifying, examining all those details are provided in the resolution plan. So approval of base resolution plan. Here the important aspects is COC may approve the resolution plan if it does not impair any claim owed by corporate debtor. So what is that impair? The impair is nothing but there is a claim, because already in the previous slide I told that the base resolution plan should ensure that it is offering to all operation creditor. So suppose the base resolution plan is not offering to operation creditor, then it becomes impaired. So what will happen? Impaired will get disqualified. No, again the COC has got a power to insist the CD to revise and okay. Otherwise it will be rejected. No, then too it will go for public. If public, the resolution plan invited from public outside, then it is not matching to the requirement of base resolution plan. It is inferior than base resolution plan. There is no other option. They have to come back to the base resolution plan. Claim shall be considered to be impaired where the resolution plan does not provide for full payment to confirm the claim as per the updated list of claim. Okay. Now, what will happen if base resolution plan is not considered? If base resolution plan is considered and approved, there ends everything. After that, there is no other process to be followed, because once base resolution plan is approved, given by CD, is approved by COC, then there is no other process to be followed. The RP has to make an application with the adjudicating authority and see that order is obtained from honorable adjudicating authority and proceed further. In case base resolution plan is approved by COC, if base approved resolution plan is not approved, then what will happen? Then we have to, the COC has to advise, will advise the RP, will go for outside public. Okay, now this is the first time where the RP will go outside the scope of corporate data and look for some good, better resolution plan from the public. Okay, when the base resolution plan impairs any claims of the owed by the corporate data to the operation data, the RP shall invite a prospective resolution applicant to submit resolution plan to compete with the base resolution. That means the base resolution plan is very much there. So he has to see that he is getting a competitive resolution plan from outside. The RP shall publish the brief particulars of the invitation of the resolution plan in Form P11 and not less than 21 days from PPRP commencement date. The P11 shall be published on the website of the corporate data 1, website of the board IBC 2, and what are the manner the COC may prescribe. The content of the invitation of the resolution in P11 shall state where the invitation for the resolution can be downloaded from or obtained where it can be downloaded. That means it should state that it should provide for last date for submission of resolution plan, and which shall not be less than 15 days from the date of invitation of resolution plan. Shall detail each step in the process and manner to be followed, and also shall not require any non-refundable deposit, and it is not permitted under IBC code, whereby the INB code does not permit taking non-refundable deposit in any stage, whether it is a resolution plan or even under the e-action also, the non-refundable deposit is not permitted to take. And now again, if you see that what is to be included, the basis of evaluation, basis for considering the resolution plan, which is significantly better than another resolution plan, and what is the size of that plan and how it can be evaluated, all this has to be and should include the name of corporate debtor and date of incorporation, and authority and identification number and register office. And what is the pre-pack insolvency commencement date? These are the details that the resolution plan, the invitation for the resolution plan should carry. Okay, the ineligibility and manner of submission, registration number of the RP, and the details about the RP, address and other details of the board data publication. Selection and approval of resolution plan by COC. The resolution applicant shall submit his plan to the RP through electronic means within the time which I shared in the previous, right? The resolution plan submitted beyond prescription shall be rejected by RP. The resolution plan so received shall be presented to the RP to the COC for evaluation, and the plan which gets highest score shall be selected for competition with the base resolution. That's why I said base resolution plan will remain. It will not be, it will not be, thrown away. I told you, the base resolution plan, though if it is impaired, it will be kept. Okay, to get a competitive plan from outsider and to compare it, see the score that, comparatively what is the base resolution plan having and the plan resolution plan given by the outside. Suppose the score is less than the base resolution plan, then COC has got no other choice. They have to relook base resolution plan. On the examination, if the COC feels that resolution plan is better than the base resolution plan, COC may select the resolution plan provided by the outside resolution professional. Whether any resolution plan received which complies the requirement, the base resolution may be considered by COC for approval. Means if there is no resolution plan received from outside, the RP may disclose the scores and call the resolution applicant to improve their resolution plan. How they can tell? It shall be completed within 48 hours. In fact, even the outside resolution plan, the RP is given a permission to improve, to insist, to advise the resolution applicant to improve the score by revising the plan to see that, but it should be done within 48 hours. The submission of the resolution plan just lower shall allow option to improve the resolution plan by at least as I say, means at least they should see that is matching certain aspects which is provided for. So here tick size means the minimum improvement over another resolution plan in terms of score as approved by the committee. The committee has to discuss in detail what should be the minimum tick size. So see that the plan given by the outside resolution applicant is improved to the tick size as prescribed by the committee of creditors. The process of the improvement shall continue till either a submitter fails to use the option at a specified time, or result having highest score on completion of the above process shall be considered by the committee for approval. The plan selected may be approved by COC by not less than 6. Where a plan is not approved by COC, then RP shall find termination of PPI. So the resolution not approved by COC shall be submitted. If it is approved, then to NCLT by RP along with the complaint certificate in form P12. If resolution plan is not approved, then the RP shall file for termination of the PPIRP. Now coming to the order of NCLT. If the NCLT is satisfied that the resolution plan meets requirement of the court, which we seen in the earlier slide, and effective for implementation, then it shall within 30 days time approve the plan. Then NCLT shall send the approval order copy to the participant and the resolution applicant. And NCLT shall within 7 days of the order intimate the claimant the principal formula as they may be for payment of debt under such resolution plan. So the order of NCLT shall be binding on, all this. We already aware in CRP order, it binds the corporate debtor. Same the case for PPRP also. It binds the corporate debtor, employees of the company, members of corporate debtor, creditors, central government, state government, local authority, guarantor, and in the stockholder in the RP. The effect of NCLT order approving the plan. After order of approval plan, the moratorium passed by NCLT shall cease to have effect. Same the case in CRP what we follow. RP shall forward all the records relating to the contact of the PPRP and the resolution plan to the board to be recorded to his database. Actions after NCLT order approving the plan. What needs to be done? Plan to be implemented in the matter specified. The resolution application shall obtain the necessary approval required under the law for time being within the period of 1 year from date of approval. And no proceeding shall be initiated against the RP for any actions of CD prior to the PPIRP commencement. A person in charge of the management of CD may make an application of the NCLT for order seeking assistance of local system, which we have provision in the normal CARP also. Termination of PPIRP by NCLT. The NCLT is satisfied if the plan does not conform to the requirement, may within 30 days pass an order rejecting the plan, or may also order for termination of PPIRP. Very importantly, termination of PPIRP by RP. The RP shall file an application to NCLT for termination of PPIRP in a scenario where there is no resolution plan approved by COC. It has to be naturally terminated at any time after PPIRP commencement date and before the approval of resolution plan. That means after PPIRP commencement and before approval of resolution plan. That's more important. The committee of creditors approves by vote not less than 66% of voting shares to terminate the PPIRP. It is possible, but it should happen before approval of resolution plan by the COC. Within 30 days of such application to the NCLT, they may pass an order for terminating the PPIRP and provide for manner of continuing the proceeding initiated by avoidance of transaction and other things. Now, termination of PPIRP by how it happens, which I told you earlier, when order has been passed vesting the management with the IRP due to conduct of the affairs in a fraudulent manner or mismanagement of affairs with the corporate debtor, the NCLT shall pass an order liquidating respect of corporate debtor. Very important. When order has been passed vesting the management with the IRP due to contact, here the NCLT shall also pass an order even liquidation respect of corporate debtor as referred in section 33, which provides for liquidation manner provided and issue public announcement and sending copy and declare that the PPIRP cost, if any, shall be included as part of the liquidation cost for the purpose of liquidation. Now, quickly coming to the relook, which I explained to you the difference between the PPIRP and CARP. I want you to take you through quickly on the difference of between directly the difference between the PPIRP and CARP. What are the difference? Quickly, a bullet point. The time frame is the CARP, as you all know, 180 days can be extended 90 days, then again 90 days, 330 days totally. Up to 330 days CARP. But here the overall time frame for PPIRP is only 120 days time. So 330 days, 120 days. CARP it is 1 crore and PPIRP the ceiling of default is 10 lakhs. So 1 crore, 10 lakhs. Then initiation of insolvency proceedings during COVID period, CARP cannot be initiated for defaults that arose between 25th March 2022, 24th March 2021. But there is no such rule for PPIRP. Very important because many matters are decided by the adjudicating authority rejecting the CARP process. That means approval of application if the default occurs during the period of 25th March 2. But that is not the case for the PPIRP. PPIRP, even the default occurs during COVID period, also, then it can be done. So this is another important thing that we have to see. Management control. The control and management based with the IRP. PPIRP, the existing management may retain with the existing management, the board. Who is the initiator here? CARP can be initiated either by the FC, OC or corporate terms. Whereas the PPIRP IRP can be initiated only by the CD. That means section 10. In case of CARP, section 10. The same the case for PIRP. In case of PIRP, only by the corporate data it can be initiated. Continuity of business. If you see that management based with the IRP in case of CARP, the management based with the existing management in case of PIRP. The cost factor, almost you know that the time constraint CARP, many things there, the management will, in case of CARP, they will disown because they are suspended. The powers of the board is suspended, whereas in case of PPIRP, management retains with the same management, the same CD. Therefore, they have to take care of the cost involved. The eligibility, what is the eligibility? CARP is applicable for both MSME and non-MSME, whereas PRP is only for MSME. Same way, resolution plan, CRP resolution plan framed only after the initiation of CRP. Whereas PPRP resolution plan negotiated between the corporate debtor and creditor before initiation. That's why we call it base association plan. But basically, it has to be given to the knowledge of the financial creditor to make sure financial creditor is comfortable to take it forward. When the financial creditors accept in principle, then only the process further proceeds towards PPARP, initiating a PPARP, then making an application to the RP. Because for that, in principle, the financial creditor should satisfy before filing an application. Whereas CRP, it is not so. CRP, the picture of financial creditor and COC comes only after admission of application and commencement of CRP and constitution of the COC. Whereas in PPRP, the role of COC or not COC, the role of financial creditor starts from the day one. When the CED proposes to file and initiate an PPARP, he has to make sure that he is convening a meeting of financial creditor and presenting before the financial creditor all the required detail and getting his in principle concurrence. After that, getting in principle concurrence only, he can proceed further towards the moving an application before Honorable Adjudicating Authority. So CRP is a formal mechanism. PPRP almost is facilitated out of court restructuring path. That means before kickstarting the court process, okay, the PPRP process ensures that in principle the like OTS, like outside the court one-time settlement out takes place. Same way PPRP ensures before coming to the court, to some extent the financial creditors are convinced and agrees, then the process is moved. Not like CRP where once the CRP is commenced, the financial creditor themselves object the CRP in many cases. So that will not happen in the in case of PPRP, because it is the PPRP is commenced with the blessings of financial creditors. So there cannot be objection after PPRP is commenced, since it's already got the blessings of the financial creditors. So this is my entire slide. So before closing my presentation, I thought I should take you through one important order, NCLT order, which is passed in this. Then you will be in a better position to appreciate how this PPRP process really works, so that it will be easy to you to so I hope you are all able to see. You could able to see the order? Can anyone confirm? Are you able to see the order? NCLT order?
Yes.
Yeah.
Yeah.
Fine. Now see, this is the order passed by principal bench of NCLT in one of the PPARP matters. Okay. Here, very important here is that why I wanted this particular order to be shown to you is that whatever we have seen theoretically in last 2 hours, 2.5 hours, what I have seen, you can see how the court, how the Honorable Adjudicating Authority looking at before passing an order, and what are the aspects they literally take into consideration before passing an order. If you see that in this present case, NT International Limited, they are only the corporate debtor, and they are only seeking the initiation of pre-packed insolvency process in respect of NT International Limited. If you see here, the corporate debtor is a public limited company, and what is the total amount debt payable by CD in this case to its financial creditor is stated to be, this is provided in the order itself, stated to be 12 crore 53 lakhs. Due is more, but company falls within the category of MSME. The loan was initiated, sanctioned, and much before April 4, 2009, subsequently renewed. Now what happens? The corporate data, the default of corporate data is against the secured financial creditor. Unrelated secured creditor. Related may be more, unrelated financial creditor is more to the tune of 31 lakhs, which can be seen from the comparison which the order provides for, which the order states that comparison of the sanction limit, they could, the Honorable Court, adjudicating authority, they could able to understand from this detail. And here what the order says, the order provides that RP has also confirmed that there is a default again OC which has been examined in the notice received from OC. So now what is recorded in the NCLT order, where the reason for losses, what is the loss? That reason stated is that post demonetization implementation of GST, the company started incurring loss. This is the reason provided in this particular matter. So, but due to the COVID pandemic, subsequent lockdown, insufficient of working capital, because of the reason, the company, default is took place. That's what the justification is given. All the financial detail, all details are provided in the order itself. It's completely a kind of a speaking information is given on financial aspects. Now, what's the step taken by the management for revival? That's provided in this. The company has installed the 7 take missions. Although technical side they are narrating, what are the steps taken by the management to prove the genuineness that they given? They put a real effort and genuine effort to make sure to bring out the company from the sick or from the financial crisis. So they put effort. In spite of that effort, they could not bring out the company. That's what they are trying to narrate here. They stated, which is recorded in the order. Now, what are the statutory compliances which the order provides for? The corporate data is duly registered. It's recorded in the order that CD is duly registered with the MSME. That means they registered MSME. This is the registered one, and certificate also as annexed along with that application. Therefore, the CD is eligible. Then a association by the members of the CD to initiate PARP. PPARP was passed on April 2022. That also annexed in the form of affidavit. A declaration given by the majority of directors, which I stated in the beginning of the slide. A declaration should be given by the majority of directors in the form P6, which is also annexed in the application as stated in the order. And the financial creditor has approved a decision of the directors to file this application. See, this only I said. The financial creditor role come much before filing the application before the Honorable Adjudicating Authority. So, in principally, the financial creditor is approving the decision of the director to file this application. Suppose the financial creditors do not approve, then they cannot file application. That means the concurrence of the financial creditor is mandatory to proceed further with the filing an application by CBP. In application form P4 along with the form P2 as contemplated in section 54. So here this is all this process has been followed in this case. So after considering all this formalities, then claim of 2 related OC also is considered in this matter, and 61 operation creditors tuned to the 2 crores 77 lakhs and odd has also been considered. And the financial creditors approved the appointment of insolvency professional. See, here in principally the financial creditors has already approved the appointment of IP in this case, and which has also been produced as an annexure. Thereby comply the provisions of section 54A to E of the IBC code. Okay. Now it's very important to see that said IP proposed to be appointed as to conduct the PPRC to discharge duty after taking his consent. The RP's report under 54B also to be attached here with it. Now the details of base resolution plan itself has to be given. So this only I said the scope of base resolution plan also comes much before. It's stated by the learned counsel applicant that benefits of all the secretary of company, the proposal of OC and financial is what are the base resolution plan provides for. Replacement of machine, all this is provided. Probably you can Google it and share, or I will share the copy of the order also to you. Leisurely, you can go through how this order, narrated or stated, and how the disbursement take place after the, approval of plan, how the disbursement will take place. All that is stated here. And declaration regarding non-existence of avoidance transaction also provided here. And affidavit stating that the corporate data is eligible under 29A also is stated. Then the debtor has also produced a financial statement for 2 years, which you have seen earlier. The 2 years providing attachment in the application is mandatory. So they complied that aspects also. They furnished the name of the insolvency professional to be appointed as a, which I already showed to you. Such RP also is given consent that has been attached. So they're producing all that. So the Honorable Court Adjudicating Authority is convinced, okay, that the application can be admitted. Can be admitted under section 54C, commencing the PPRP process. So once the order is confirmed, commencing the PPRP, the application is complete and it is admitted, then the application of PPRP, then immediately the moratorium starts. So the moratorium portion is reproduced similar like CRP orders. The moratorium PPRP, the moratorium provision has been stated and recorded in the order itself, giving moratorium benefit to the PPRP process to the CD under what is available under section 14. Same way the RP as proposed by financial director is appointed RP to conduct the PPRP has been provided that and his duties and responsibilities also, functions also is recorded what is to be done as per provision section 54F of the code. Then after this, the order also provides that the RP to make a public announcement, just like CRP, how the RP make, IRP will make, here RP will make a public announcement. Same way the order provides for that section 54F subsection 5, the personal of corporate shall extend all. So this also is provided in the order itself, that all the orders, cooperation has to be provided. In case of non-cooperation, the RP can initiate. In fact, this also forming part of the order that RP can initiate file an application under section 92 in case of non-cooperation from the corporate data. Okay, that also is recorded in the order. And the board of directors will be detached in case the order provides for vesting of management with the RP. We direct the RP to file interim report within 30 days. This is how the whole report orders is passed by the Honorable Adjudicating Authority, and almost similar manner, but they are very specifically, all the sections are captured. Very specifically, all the annexures are said to be complied with. So it's properly it is narrated. Then after ensuring the application is complete in all respects, the detailed order is passed in this matter. So this is all about pre-pack insolvency. In fact, with the order of Honorable Adjudicating Authority, the two principal bench order, I think we will try to understand better the pre-pack insolvency process. If any query on this, you can always give to me. We will discuss all. I'll take up all your points. I'm done with my presentation. So we can, if any queries, please, you can raise your queries. We can discuss and we can proceed further.
Just one question, sir. When in the case of PPRP, the control is with the corporate debtor and the directors are managing the affairs of the company. What is the purpose of taking custody and control of the assets by RP? Why RP should take control?
No. When RP will take control, RP will not take control. In fact, as I narrated earlier, the control and management affairs of the company and assets of the company will be very much with the board only, with the same management only. Only when a fraudulent act done by the management, then COC can resolve that management can be vested with the RP. Then RP will move an application with the NCLT. then
Okay.
SAP will pass.
Okay. In that case only.
Any other questions?
There are not many PPRP cases, so there is no practical experience with the
Yeah.
professionals.
Yes. But almost similar like CRP only, with the minor changes here and there are changes are there. But those who have done CRP can manage to handle. Those
But
who
it is not taking off.
yeah.
See,
That is there.
Sir,
many
the
people are hardly
the
any cases
threshold-
of PPRP.
Sir, one at a time. Sorry?
Hardly any cases of PPRP.
Yeah, correct. Because all MSME will go into OTS itself, they will settle. Instead of saying it as a plan, they will try to settle in OTS itself with the bank because amount will be small. No? Since being a MSME, they would have taken a loan values, lesser value, loan value. So they will buy OTS.
Basically, the provisions have failed. PPRP has failed, miserably failed.
Plus PPIRB, banks have to take decisions upfront, which they never want to take. So why will they take an haircut without somebody telling that you have to take an haircut, which is the case in PPIRP. So they are also not interested in PPIRP, I guess.
No, it is like a LLP, I have to say, limited liability partner. When the provision came, after even, I remember LLP Act came 31/3/2009. I remember the provision. After 10 years also, it was not picking up. Hardly very few thousand LLP formed. But you see, in matter of 3-4 years, nearly more than 1 lakh, 2 lakhs LLP has formed. So we never thought of this level LLP will be formed. So like that, we have to wait and see. If a situation changes, if some advantages bank gets, immediately they will, some protection they get, immediately they will, probably some amendment.
Right now, we don't foresee both sides getting in this benefit. So yes, as you rightly said, anything comes in IBC 2.0, 3.0, something comes up out of the blue, then yes, it will.
As I was telling, the default amount will be less being the MSME.
What do you feel?
Yeah.
What do you feel can be done to motivate or promote PPRP? What can be done? What is the flaw? Except that the bankers are not ready to accept the base plan, because in that case they have to accept the haircut in advance, which is not which they don't want to do.
See, if you see that the moment the promoter and bank talks, in case of normal CRP, the promoters and bank have no scope to talk. Okay, they can come and object and do whatever they can do. If adjudicating authority permits them, entertains them, they can do objection. But there no negotiation takes place to settle the issue unless the court gives an opportunity that you settle. Suppose 12A, you can withdraw, right? So unless, otherwise scope is very less. In fact, most of the CRP cases, financial creditor react after CRP gets admitted only. But here, since the financial creditor is consulted much before, inside the room itself, boardroom itself, things are getting settled, right? That's why the purpose is getting,
And Dhanpalji, as you rightly said that if there is only one financial creditor, then they don't even need PPIRP. Then OTS is a much easier option. Instead of getting a new person called RP into picture, they can decide on themselves. Why do they even need to pay fees for RP? Until unless there are 4-5 banks which are involved and they are not coming on single page, then you propose PPIRP.
MSME, MSME being a small, medium, micro, it's very, very few only medium. Most of things is small and micro only, if you see. Small level people are, and medium is very lesser number only. So those people will have a bank account only or dealing with only one financial creditor, most of the cases. In normal CRP, you see 10 banks are involved. In certain cases, 15-20 banks are involved.
So just to answer Anilji's query, Anil Kumarji's, Sir, I think real estate cases can go into this PPIRP. I'll tell you why. Because when courts have devised this reverse CIRP, I don't know what it is, reverse CIRP. Even everybody, the home buyers also want the developer only to finish it. They want them to be in control instead of a new person. So as you were saying, what can be included, I don't know what really can be included right now, but I think PPIRP might be suitable for real estate kind of cases.
That will suit for that only. Yes, real estate only it will suit. Reverse.
The other thing which Dedaji that can be done, in my view, that the base plan which is submitted to NCLT along with the application should have already enjoyed the approval of higher authorities of the bankers.
Yeah,
So
correct. Yes.
they should have before it is accepted by the COC at GM level, the whatever higher authority which is involved, competent authority, it should have approved so that they get immunity of any action taken against the COC members who have accepted the base plan. Tomorrow you get a higher plan which is much more than the base plan, then they will be criticized or they will be attacked that why did you accept? So some sort of sanctity should be provided, some authority should be provided to the COC members or minimum level of authority who can approve the base plan. That is the inhibiting factor. Devdaji said, as you rightly said, that since base plan acceptance is a challenge, they don't want to accept, unless it is stamped by NCLT. In this case, it is before the NCLT approves the plan or before.
See, once it comes to the NCLT, then only the outsiders get opportunity. Before that, the outsider is not getting opportunity. So banker themselves, they can see that if that the OTS kind of thing is done and they are closing it, being a small amount, rather than getting into the court process, better to close down and come into some form of agreement. They will sign up and they close. So very few matters only coming across to the court towards PPRP.
Another thing which can be done to give credence to the base plan is that valuers can be appointed pre-hand by the bankers, so that while approving the base plan, the bankers and the financial institutions and COC knows the fair and liquidation value of the corporate debtor.
But they are doing that already.
But
they are doing that already.
But
how will they come out with the PIPR?
So that should become a formal part. Because valuers are appointed after the commencement of PPRP within 3 days. Instead of that, the base plan should be linked with the fair and liquidation value.
Actually, bankers will not permit. You take it from me, sir. Bankers not ready to compromise and all. Unless they have no option, only they are compromising. Otherwise, they expect always more only.
Absolutely.
Let them expect.
Give up on all. They want more only bankers.
No, everybody wants more. Since their expectations are not being fulfilled and there is a default, that is why PPRP is there. It is good to expect more. But the point is that a business is failing. Default has taken place. That is why PPRP, CRP, OTS and settlement are taking place.
End of the day, even you involve whoever you want to involve. I'm also registered valuer. You appoint anybody, take some value. End of the day, as a banker, okay, he says, no, I'm not accepting. What you can do with the banker? I'm saying some X value. Whoever involves, whoever gives some value, registered valuer or whoever it is involved, give some X value. And the corporate debtor approaches bank with that X value. Bank is going to say, unless they are happy, they'll say, no, we are not happy with this value. Go and improve and bring. I'm saying in a much earlier stage itself, not in the NCLT. So unless banker is comfortable, is convinced that okay, this amount is okay with us, then only they will permit. Otherwise, they will
Agreed. But we have to change when there is a disease. The mindset of the bankers have to change. Either they should be legal mandate by the RBI that in case there's a default, please follow PPRP process. No, something should be done. Otherwise, why to have PPRP when they have the mindset of not accepting any settlement, not accepting any base plan, then
Anil Kumar ji, in CERP, in most of the cases, I think most of our friends will agree with me. Even now in CRP, I know how many my insolvency friends are facing difficulty in dealing with the financial creditors.
yes, yes, sir. That is true.
I know each and everyone on a daily basis. Maybe few the COC members will be very cordial and they'll be cooperating fully with the RP and things will be moving on. But most of the cases which I'm also getting to know that they are struggling with that, because if they're assuming there are 10 banker sitting in a COC and 10 banker will have 10 expectation and bringing all them in one page, and here the RP really more than
Yeah.
Dhanpal ji, that's what we are saying, that when they don't agree in CIRP, how do
Yeah.
you expect them to agree beforehand? And that too, in PPIRP, maybe the best plan says that the personal guarantee also will be waived off or supplemented with something else.
No,
So even that option might go away.
no, what I'm saying, when I agree with your point that before coming to the court, if FC agree, it's a smooth only, travel is smooth.
And it's
No
very,
doubt.
that's
No
wishful
doubt.
thinking. That is
But-
wishful thinking.
Correct. But with the compulsion that there is an judicial authorities involved in the process, then to COC members and financial creditors, they decide in their own way only. Okay?
Yeah.
Their own way only. Knowingly that judicial authority is involved. Then how you expect they will be completely dealt with each other before judicial is involved when they are sitting in a boardroom? They will give their own demand. Unless all 10, like consortium. If it's a consortium, they will agree. Because
But-
one person, they will depend on one person. If not a consortium, then 10 banker will have 10 view.
So the experience tells us there is a great great need for the guidelines for the COC to be
Sir,
adhered. COC,
already we took effort also, some code and so they brought also, sir. But unfortunately, Reserve Bank of India has to give some form of a guideline for the bank.
yes, sir, because Reserve Bank of India is their regulator. So what we understand now, for the success of CRP or for removing the obstructions in CRP and success of PPRP, some sort of strict guidelines have to be issued by RBI with the help of IBBI. You know, because RBI is their regulator. So IBBI guidelines, they are not mandatory, they are not enforceable on them. They issued guidelines, they did not accept it. They were withdrawn. So let IBBI and RBI put together issue guidelines for COC, then only. Otherwise, they will not change the mindset. Because they should have legal, because they are challenged. Their higher authorities challenge them. Why did you accept this plan? Why did you accept this haircut? You know.
Sir, they are.
Palji, I might have missed one point. Can I ask this PPIRP, can this be done for operational creditors also? Like if you have only operational credit?
No, but you need to get a concurrence of financial creditors. No, then only you can.
No, suppose I don't have financial creditors. Suppose I don't have, I have only operational credit.
Okay.
Because in OC can go for section 9. But in this case, can an OC, if you have only OC
Constitution
credit?
provides for constitution of OC in case of there is no financial creditor.
Correct.
Applying the same ratio, things can be worked out and the court should be convinced.
We haven't seen any case, but it is possible, right? Under the code.
Court has.
Devdetji,
Since the provision permits us to form a COC.
in this, Ranaji, in the case of PPIRP, the application has to be filed by the corporator itself.
Yeah.
So corporator can
I
file.
understand, sir. I
Yeah.
agree. I was only saying, can we reduce our operational credit debt also just by doing this, even if we don't have an FC?
Certainly,
So
if the
you are saying by
corporator,
ratio it should be.
yes,
Yes.
corporator is not able to run the business because of the liability either on account of financial debt or operational debt. You
But
know,
that should not be financial debt. Then only operational debtor, the other creditor will have some.
Certainly.
will have
It,
some-
ne- yeah, it needs a prior approval of FCs. If there is no FC, then only OC.
Okay.
Thank you, Dhanpalji. Thank you so much. It refreshed our provision, which we forgot completely. Because there is no practical experience about BPIRP. We had, it has gone into our subconscious mind.
Madam, shall we officially close or any other questions?
Sure, sir, we can close. Thank you so
Thank you.
much, sir, for such an interactive and wonderful session. Further, all the participants are informed that tomorrow's session will take place between 9:30 a.m. to 12:30 p.m.
Okay.
Okay.
Thanks a
Thank
lot
you.
for the participants for your patient sharing. Thanks a lot. See you.
Thank you. Thank you, Dhanpalji.